Good evening, I'm Marty Olson, and welcome to another edition of City Focus. Tonight my scheduled guest is Bill Cornish, and Bill is not here on the set yet, and I sincerely hope that he gets here relatively soon so we can have a vigorous discussion of the primary issue being the budget referendum and the mayor's edict that he is going to go along with the law director's opinion that the issue is in essence moot. I'd like to point out to everybody that we are live this evening, and you can certainly give us a call at 860-440-3154 or 800-253-2285, and the numbers are on the screen. And I would encourage you to call if you've got a thought or opinion on whether a petition for the referendum, a second petition, should I say, because we've already had one and one referendum, and the budget was defeated and has since been modified by the City Council and signed by the mayor, and whether or not you think that the work that's been done to date is sufficient and adequate, or perhaps that you may think that we should be petitioning a second time to get another referendum vote and require or request for additional cuts and reductions in the taxes and mill rate. I did bring with me this evening a copy of the June 2010-2008 case, Hample versus the City of New London, as a background for discussion for tonight's session. And I'd like to just kind of review some of the information here within, because this is a primary basis for Attorney Londrigan's opinion that the 25% has of the budget for this current fiscal year has already been expended, and therefore we cannot, a petition would be irrelevant and moot, and therefore we should not move forward in that area. So if you will bear with me, this is a memorandum of decision, a motion to dismiss from the Superior Court the plaintiffs, Barbara Hample, Dorothy Mansfield, Elizabeth Crossley, Lawrence Hample, and Dwight Gross, electors of the City of New London, seek relief from this court by way of a writ of mandamus. They claim that they have followed the proper procedure required by the City of New London City Charter for filing a referendum petition requesting that the 2007-2008 budget for the City of New London be either repealed or submitted to a vote of electors. The plaintiffs want this court to declare the referendum petition valid and order and direct the defendants to promptly submit the same to the voters of the electors of the City of New London at either a special election or the next municipal election. Now, at the bottom of the page it reads as follows, and this is from the court. For the reasons herein stated, although this matter was brought before this court as a motion to dismiss, the court treats it as a motion to strike, which motion is hereby granted in part and denied in part. And I think that's what the crux of what this discussion is all about. 4 years ago, the court kind of punted. Yes, we'll allow this, but we won't allow that, but didn't take a definitive decision on the whole. The named defendants are the City of New London, Michael Tranquita in his official capacity as the city clerk, Martin Berliner in his official capacity as the city manager, and Margaret Curtin, Kevin Kavanaugh, Elizabeth Sibilia, and Jane Glover in their official capacities as member of the City Council. Specifically, the plaintiffs allege in count 1 of the amended complaint the following. On October 2nd, 2007, the plaintiffs filed a referendum petition which met the requirements of the City of New London Charter requesting that the budget of the City of New London be either repealed or submitted to a vote of the electors. Although the city clerk was required by charter to determine the validity of the referendum petition with 10 days of its presentation and submit it to the City Council at its next meeting, which was scheduled for October 15th, 2007, he failed and refused to do so. As a result, the referendum petition was not submitted to the City Council meeting until its meeting on November 5th, 2007. On November 5th, 2007, after initially voting unanimously to receive the referendum petition as valid, the City Council then recessed for approximately 5 minutes and subsequently voted to dismiss the petition as invalid. The City Council also voted not to accept any referendum petitions on the budget after the city expended an amount of money equal to 25% of its previous year's budget, which the defendants claimed to have occurred on November 2nd, 2007. There is no provision in the charter that authorizes the City Council to dismiss an otherwise valid referendum petition on this basis. So this action was illegal and invalid under the Home Rule Act, General Statutes 7-187 through 7-192. The defendant's refusal to submit the measure contained in the plaintiff's referendum petition to a vote of the electors of the City of New London deprived the plaintiffs of their rights to due process in violation of Article 1, Section 8 of the Connecticut Constitution and the 14th Amendment to the United States Constitution, and their right to petition in violation of Article 1, Section 14 of the Connecticut Constitution and under the New London City Charter. The plaintiffs further allege in Count 2 of the amended complaint that the defendant, City Clerk Tranquita, acted in concert with the other defendants to delay certification of the petition and the submission to the City Council until after the City of New London expended an amount of money equal to 25% of its prior year budget in order to dismiss an otherwise valid referendum petition and prevent a submission of the budget to a vote of the electors of the City of New London. By way of relief, the plaintiffs seek an order of mandamus determining that the referendum petition is valid, an order directing the defendants to promptly submit the same to a vote of the electors of the City of New London at either a special election or the next municipal election. On January 14th, 2008, the defendants filed a motion to dismiss on the ground that the court lacks subject matter jurisdiction over the mandamus action. The plaintiffs opposed the motion, asserting that the court does have the subject matter jurisdiction over the plaintiff's mandamus action and that it satisfied the test for granting a writ of mandamus. The defendants request alternatively that if the court finds that it does have subject matter jurisdiction, it should treat the motion to dismiss as a motion to strike. Oral argument was held before the court on February 11th, 2008. Folks, I'm going to, in the absence of Mr. Cornish, wade through this case, and I'm on page 4 of 10, and I will refer back to a few items that have come with the court as well. And I would encourage folks, if you're watching, would like to interject your thoughts or concerns, or perhaps some issues regarding this, because I think this is directly related to what we're facing today. From the court, the filing of a petition is permitted pursuant to Section 30 of the New London City Charter, which states, quote, if within 15 days after the final passage of a measure by the council, a petition signed by electors of the city equal in number to at least 10% of those who voted at the last preceding regular city election be filed with the city clerk, requesting that such measure, or any part thereof, be either repealed or submitted to a vote of the electors. It shall not, unless it be an emergency measure, become operative until the steps indicated herein have been taken. Such petition shall be known as a referendum petition. The court notes the filing of certification is governed under Section 36 of the New London City Charter, which states in relevant part, quote, within 10 days after the petition is filed, the clerk shall determine whether it is signed by a sufficient number of electors and shall attach thereto a certificate showing the result of examination," unquote. The submittal of referendum petition to the council and electors is governed by Section 31 of the New London City Charter, which states, "If a referendum petition or amendment petition be found sufficient by the city clerk, he shall certify that fact to the council at its next regular meeting. Upon receipt of the clerk's certificate, the council shall proceed to reconsider the measure or part thereof, and its final vote upon such reconsideration shall be upon the question, quote, shall the measure or part of the measure as specified in the referendum petition be repealed," unquote. If upon such reconsideration the measure or part thereof be not repealed, it shall be submitted to the electors at the next municipal election held not less than 30 days after such final vote by council. The council, by 5/7 vote of its members, may submit the measure to the electors at a special election to be held not sooner than the time aforesaid. If, when submitted to the electors, any such measure or part thereof be not approved by a majority of those voting thereon, it shall be deemed repealed. Now, folks, I want to remind you this is the court rendering from June 10th, 2008, regarding the issue of petitioning referendums on the budget and the expenditure of 25% of the funds from the prior year's budget in this current fiscal year, and the relevant roles and procedures and due process, and how that may impact questions that are being discussed and debated today. Of course, we have now transitioned our government from the city manager council to mayor and council, and it's evident that there's a disagreement between the mayor and the city's legal counsel, Jeffrey Londrigan, and some members of the city council. I am led to believe that there are members of the community being led by the group Looking Out for Taxpayers, also known as LOT, that they will be circulating a petition regarding the budget and looking for a second petition and referendum on such item. I am not sure, sitting here this evening, on the validity of this or where it should be submitted to. The agent for service for the City of New London, who receives all documents of this ilk, would be the city clerk's office. And the city clerk actually works primarily, but not exclusively, based on state law and state statutes. So therefore, the ruling late last week by the mayor that when he directed the clerk to not accept any petitions in this area was in fact flawed and you might say illegal. And to the best of my knowledge, Mayor Finizio has withdrawn that specific directive. However, once accepted, what will the clerk do? Will he sit on it? Will he in fact do what's been suggested here in the court order, which would be to check out the signatures for validity and see if it meets the requirement of the 10%. And then will it be sent to council for consideration? Based upon the mayor's remarks last evening at the council meeting in council chambers, it certainly seemed to me, observing that the mayor has no intention of seeing this material making its way to the council. Now let me continue with the case. And before I do, again, the numbers are on the screen if you would like to offer some thoughts and input. Locally, we are at 860-440-3154, or you can call 800-253-2285. On January 14th, 2008, the defendants filed a motion to dismiss on the ground that the court lacks subject matter jurisdiction over the mandamus action. The plaintiffs opposed the motion, asserting the court does have subject matter jurisdiction and has satisfied the test for granting a writ of mandamus. The defendants request alternatively that if the court finds that it does have subject matter jurisdiction, it should treat the motion as a motion to strike. An oral argument was held February 11th, 2008. And you might note as well that between the time of submittal and getting into court, the wheels of justice don't move at a warp speed here. So time is moving along relatively slowly, and I would anticipate a situation of similar nature that we're looking at here today. Now, quote, a motion to dismiss properly attacks the jurisdiction of the court, essentially asserting that the plaintiff cannot, as a matter of law, in fact, state a cause of action that should be heard by the court. A motion to dismiss tests inter alia whether, on the face of the record, the court is without jurisdiction, unquote. Cox versus Aiken, 278, Connecticut 204, 210-11, 897, A2D 71, that's 2006. Quote, when a court decides a jurisdictional question raised by a pretrial motion to dismiss, it must consider the allegations of the complaint in their most favorable light. In this regard, a court must take the facts to be those alleged in the complaint, including those facts necessarily implied from the allegations, construing them in a manner most favorable to the pleader. On February 11th, the plaintiffs filed the amended complaint to include in the order of mandamus to direct the defendants to promptly submit the referendum petition to a municipal election. Now, the defendants argue that the court lacks subject matter jurisdiction over the plaintiff's mandamus action because the plaintiffs do not satisfy the three-part test of mandamus action and are not entitled to their requested relief. Whether the plaintiffs have satisfied the requirements of a mandamus action goes to the merits of the plaintiff's amended complaint rather than the court's subject matter jurisdiction. See Duramo versus Smith, that's 2005. The trial court's determination that a statute is not retroactive and therefore that the plaintiff has no clear right to the relief sought concerns the merits of the plaintiff's mandamus action rather than the trial court's subject matter jurisdiction. And they referenced the Connecticut Pharmaceutical Association versus Milano in 1983. A ruling on a motion to dismiss is neither a ruling on the merits of the action nor a test of whether the complaint states a cause of action. And referenced Doctors Associates, Inc. versus Keating, 2003. Since the defendant's challenge to the amended complaint is focused on the sufficiency of the plaintiff's claim for a writ of mandamus, the court accepts the defendant's alternative suggestion and treats the motion as one to strike. I would interpret that in that particular area that the city, the defendant's alternative suggestion would be that the city wins that point. The Supreme Court has approved the procedure for treating a motion to dismiss as a motion to strike where appropriate. And we have referenced Grigliacci versus Meyer, McCutcheon and Burr versus Berman. Those are both in 1991. Quote, the purpose of a motion to strike is to contest the legal sufficiency, the allegations of any complaint, to state a claim upon which relief can be granted. The ruling on a motion to strike, the court is limited to the facts alleged in the complaint. The court must construe the facts in the complaint most favorably to the plaintiff. And we have referenced Waters versus Autori, and that is 1996. Under practice book, a party may, in motion to strike, challenge, quote, the legal sufficiency of any prayer for relief in any such complaint, unquote. Moving on. Quote, mandamus is an extraordinary remedy available in limited circumstances for limited purposes. It is fundamental that the issuance of the writ rest in the discretion of the court, not an arbitrary discretion exercised as a result of a caprice, but a sound discretion exercised in accordance with recognized principles of law. That discretion will be exercised in favor of issuing the writ only where the plaintiff has a clear legal right to have done that which he seeks. The writ is proper only when 1, the law imposes on the party against whom the writ would run a duty, the performance of which is mandatory and not discretionary. 2, the party applying for the writ has a clear legal right to have the duty performed. And 3, there is no other specific adequate remedy. And we have referenced Camerata versus Planning and Zoning Commission, and that was in 2006. Quote, there is authority for the proposition that even when a plaintiff has a clear legal right to the writ, principles of equity and justice may militate against its issuance. Courts have discretion to consider equitable principles when deciding whether to issue the writ. The writ of mandamus will be granted to prevent a failure of justice, but never to promote manifest injustice. It is a remedial process and may be issued to remedy a wrong, not to promote one, to compel the discharge of a duty which ought to be performed, but not to compel the performance of an act which will work a public and private mischief, or to compel a compliance with the strict letter of the law in disregard of its spirit, or a palpable fraud. The relator must come into court with clean hands. And we have referenced Jalowick Realty Associates, LP versus Planning and Zoning Commission, and that's 2006. The relief requested by way of an order of mandamus is to declare the plaintiff's referendum petition valid and to order and direct the defendants to promptly submit the same to the vote of the electors of the City of New London at either a special election or the next municipal election. While the plaintiffs have sufficiently alleged the necessary elements in support of a writ of mandamus concerning the validity of the petition, an examination of the relevant charter provisions reveals that they have failed to properly set forth their entitlement to a mandatory order concerning submission of the referendum petition to the vote of the electors of the City of New London at either a special election or the next municipal election. Articles 4 and 5 of the New London Charter clearly establish the requirements and procedure for a valid referendum petition. Section 30 of the New London Charter, which governs the filing of petitions, states, quote, if within 15 days after the final passage of a measure by council, a petition signed by electors of the city equal in number to at least 10% of those who voted at the last preceding regular city election be filed with the city clerk requesting that such measure or any part thereof be repealed or submitted to a vote of the electors. It shall not, unless it be an emergency measure, become operative until the steps indicated herein have been taken. Such petition shall be known as a referendum petition. Section 36 of the New London Charter governs the filing for certification, which states in a relevant part, quote, within 10 days after the petition is filed, the clerk shall determine whether it is signed by a sufficient number of electors and shall attach thereto a certificate showing the result of his examination, unquote. In the amended complaint, the plaintiffs have alleged sufficient facts in support of their claim that the referendum petition was signed by the requisite number of electors, was otherwise valid in all respects, and that the city clerk failed to certify it within 10 days of its filing. In applying the three-pronged test for the issuance of a mandamus to declare a valid referendum petition, the plaintiffs have sufficiently alleged that certifying the validity of a referendum petition in accordance with the city charter is a ministerial and not a discretionary act, and that they have a clear legal right to file a referendum petition and that no other adequate remedy exists. And this is the key issues at hand here that we're looking at as we move forward with our own situation. The defendants argue that the court should use its discretion to deny the plaintiff's writ of mandamus, even if the court concludes that the plaintiffs have pleaded sufficient facts to overcome the three-pronged test for a mandamus, because the impact on the City of New London and its taxpayers would be disastrous. Specifically, the defendants claim that allowing the plaintiff's petition, the third one to be filed challenging the 07-08 budget, after 25% of the budget has been expended, would essentially cause the city to be shut down and render it unable to expend money to pay police officers, firefighters, public works employees, teachers, and school officials. This argument addressed the equities of the respective parties' position, goes to the merits of the plaintiff's claim, and is an improper argument in support of a motion to strike and must be disregarded by the court. The court will not resolve equitable issues in the context of a motion to strike. They're referencing Barton versus Waterbury, and that was in 2001. The plaintiffs also seek a writ of mandamus ordering and directing the defendants to properly submit the referendum petition to a vote of the electors of the City of New London at either a special election or the next municipal election. An examination of the relevant charter provision reveals that the relief sought implicates discretionary acts by the defendant members of the City Council. Section 31 of the New London Charter governs the submission of the petitions to council and electors, which states, quote, if a referendum petition or amended petition be found sufficient by the city clerk, he shall certify that fact to the council at its next regular meeting. And highlighted here, upon receipt of the clerk's certificate, the council shall proceed to reconsider the measure or part thereof. And moving on, and its final vote upon such reconsideration shall be upon the question, quote, shall the measure or part of measure as specified in the referendum be repealed? And again, highlighted, if upon such reconsideration the measure or part thereof be not repealed, it shall be submitted to the electors at the next municipal election, held not less than 30 days after such a final vote by council. The council, by 5/7 vote of its members, may submit the measure to the electors at a special election to be held not sooner than the aforesaid time. If when submitted to the electors, any such measure or part thereof be not approved by the majority of those voting therein, it shall be deemed repealed. The court agrees with the defendants that Section 31 clearly gives the City Council the discretion to reconsider all or part of the measure in question, repeal it, and if not repealed, submit it to the electors in a manner further allowed by the Charter. Pursuant to this provision, the plaintiffs do not have a clear legal right to the relief they seek. That is a vote of the electors of the City of New London at either a special election or the next municipal election. The only clear legal right they have is to have the City Council act on the measure. Mandamus neither gives nor defines rights which one does not already have. It enforces, commands performance of a duty. It acts at the insistence of one having a complete and immediate legal right. It cannot and does not act upon a doubtful or contested right. And that's reference Tennessee versus Bridgeport, 1990. Always comes when I'm on the air. I'll have to take that later. For all those foregoing reasons, the defendant's motion to dismiss is treated as a motion to strike, and thus treated is hereby granted in part and denied in part, to the extent that the plaintiffs seek a writ of mandamus, ordering that the referendum petition be submitted to the electors in the next special election, the motion to strike is granted. To the extent that the plaintiffs seek a writ of mandamus ordering a referendum petition be declared valid, the motion to strike is denied. I think, ladies and gentlemen, a clear question here is where does the petition go for discussion? And Attorney Londrigan has referenced the 2003 referendum and also this case that went to court in his report to Mayor Finizio. And nowhere within the context of this document should this issue be referred to the office of the mayor. It should be going to the city council. I do not have the most current charter provisions at my fingertips, but what is within those documents, I think, holds the key to where this is going to go and how it should proceed. With the charter revision that was approved last term on the council in which I served on, I don't recall, and I emphasize recall, the issues being referred to the mayor, but would continue to refer to council. But again, I think that ought to be referenced and looked up, and I don't necessarily believe that it has by any of the parties based upon what has been published to date or stated in the public domain. But for those of you who are interested in this, I would encourage you to contact members of LOT. I know that they are planning to commence with a petition drive very soon. If this is something that's important to you, whether it's a case of where you think that there's room for more reduction in the budget and the mill rate, or whether you think that it's important from the rights of our citizens and due process to be able to petition in that point in and of itself, again, I think you should contact members of LOT on that as well. And again, they plan on initiating a petition drive, I believe, later this week. For those of you who may think that the administration is on solid ground, then I think that it's incumbent upon you to articulate your points as strongly as well, and hopefully be able to document them clearly as well too. There are those who would argue too, and I've got a phone call, so we're going to go to the phones. Good evening, and you're on the air. Hello?
Hello?
Yes, you're on the air.
Oh, Marty, sorry. Isn't it so that when we have a budget, all right, and a certain amount is to be allocated from property tax, but then what happens is the mill rate is changed. Now, if I read the date correctly, the mill rate has gone up 2 point something for the January over what it was in July. So they're just playing games anyway and get the total budget down, then they up the mill rate. So there's no gain for we poor property tax people. Isn't that so?
Well, I think that you are certainly have a very valid point there. The budget reductions were done primarily through a hope that they would get a reduction in debt service with the refinancing, and also another $300,000 was going to be reduced because of the finance offices of the city and the schools were not going to be combined, and that money was going to be in turn saved, and there were some other miscellaneous and sundry items, but not any significant cuts to spending, and you're correct.
Which makes it really ridiculous in a democracy that, you know, people report. In other words, this controversy is void. There is no controversy because they're going to play games and manipulate the way they want. And until politicians come to find out that we can't be fooled, no one is going to win, and we are going to lose. And thank you for listening, Marty. Good night.
Thank you very much for the call. Again, I want to remind everybody that we're live and we are on the air. You can give a call to the program tonight at 860-440-3154 or 800-253-2285. The numbers are on the screen. But I would like to get your thoughts and opinions on this. This, I think, is a very important question. I think that the decision of the court 4 years ago really was open-ended and left room for interpretation. The mayor right now is working on the legal opinion of the city attorney, Jeff Londrigan. and legal opinions are, quite frankly, just that. They are opinions. They are not a, it's not a court order. It's an opinion that can be either accepted or rejected, for that matter. And I think that that's something that we as a community have got to look at very, very carefully. And I think that the council has got a responsibility to look at these opinions very carefully. I mean, at the moment, our city attorney is serving the mayor's office, the administration, as well as the council. And I'm not so sure that this is in the city's best interest, that we have our legal counsel serving two masters. I think that often, and this may be one of those cases where it's an inherent conflict of interest. And I think that that is something that also ought to be looked at and addressed. And it may be a good exercise for the community to pursue this again through the courts in an effort to get a conclusion that will more clearly define the petition and how far it can go, and the issue regarding of the expenditures of the prior year's budget, and whether or not the city would shut down or not. If there's a ruling whether or not how many referendum petitions can be made. I don't see that that has been necessarily addressed. And what happens in those situations if a petition is submitted in a timely fashion, but then it is not in turn looked at and given the stamp of approval by the appropriate authorities, and then submitted to the proper authority above that in a timely fashion, which in turn makes the petition moot. So these are, I think, some very, very serious questions that need to be addressed, and I think that to ignore them would be irresponsible, and also setting precedent on bad precedent is not necessarily, I think, in our best interest as a community either. So, ladies and gentlemen, we are, again, I'm live. I'd love to hear from you. You can offer your thoughts, comments, and if there's some topics that we have not covered this evening regarding the city that you'd like to address, I certainly would be willing to hear what you have to say about whatever's on your mind. I know last Saturday evening there was a fine party down at the Port and Starboard to benefit the Save Our Beach organization, and I sincerely hope that they raised a bundle of money. The organization provides tremendous amount of resources back to the beach, and whatever they raise is 100% goes back into preserving and aiding our beach, Ocean Beach Park, here in New London, Connecticut. And what they're doing is special, and we should be thanking those folks who serve on that committee for all the work they do. Last week, their chair, Tom Quinton, addressed the New London Kiwanis Club, which I'm a member of, and his remarks were well received and very informative. And I would encourage other organizations and groups that bring in community folks for information, that Tom would be a good resource, and to invite him in to talk to your organization about what SOB is doing for the beach, and how they raise money, and their volunteers, and what they're doing, which is all, I think, pretty darn good stuff. Well, folks, I have to tell you, since we're not getting overwhelmed with calls tonight, I've gone over this case line by line. I've offered some thoughts for consideration, and I hope that for those of you who are watching, that you will in turn also be very thoughtful on how you feel about this issue, and how you want to approach it. And if you're out and about and there are folks circulating petitions, and if you feel strongly about this issue and would like to see it addressed further, then I would encourage you to sign the petition. For those of you who feel that the administration, the mayor's position holds water, well, do what you have to do. I think that we have a lot of murkiness here, And the phone is ringing. Good evening, and you're on the air.
Good evening. Can you hear me, Marty?
I can, thank you.
Hi. To be fair, I have been critical of, when you were running, critical of your running for mayor because you ran so much with the education that, honestly, I think you'd be a great fit on the Board of Ed. So I'm calling to say, I don't know if you know who I am or not, but I have been very critical of you when you ran. And tonight I'm going to talk about the matter of two of the counselors being city employees.
Okay.
And there is absolutely no doubt that both of them have a right to run per Connecticut state law. But moving past that, because you can tell Mike takes this very personally, and he, when he responds, he always says, I have a right, to run, I have a right, to be elected, da-da-da-da-da. But moving past that, now we go into the workings of politics in the city. And in this case, we have two unions who recently rebargained, well, not really the police, so to speak, but, the unions agreed, I think stupidly, to support the mayor in this year's budget. And it doesn't say what budget. It just says, the budget for the coming year, and also referendum. It doesn't specify which referendum. So it leaves it open to interpretation that it would be any budget, any referendum. You support me. So therein lies the problem. Although they may have a right to run and a right to be elected, things happen, and I don't think that they should be involved at all with these budget matters. And I think that seeing, them, walk in and out of the room on different subjects, people are now less apt to elect a city employee because it definitely gets in the way. But I really disagree. I really, as far as voting on budgetary matters, since the unions made that deal with the mayor, not before, but after they made the deal with the mayor, I don't think either one of them has a right to be voting on budgetary matters. They're members of the union. The union, voted to support the mayor in his budgets and in his referendums. Clearly there's a bias, and I wanted to know what you thought on the matter. I'm not talking about their right to run or be elected. Clearly they're allowed, but, I personally don't think that they should be voting on budgetary matters since their unions agreed to support the mayor, and it doesn't specify which budget or which referendum. So you just, you're assuming that this year's budget, whenever we get one, and any referendum. And I'll leave it with that. And
okay. Well, thank you very much for your call and your points, and your points are very well taken. At a personal level, last term, working with Councilor Passero, who's a New London firefighter, we really didn't seem to run into many issues, if any at all, during the course of the term that caused any static in this area. This particular term with Councilor Passero as well as Councilor Nolan, who is a New London police officer, there does seem to have been a number of issues where either one or both have had to recuse themselves from discussion. State law protects them in regards to their capacity and ability to run, and in that regard, I support the law and adhering to the law. If the law is not working, then I think that it's incumbent upon us to look at it and address it appropriately. We have some problems in the city. We have a number of we had another police officer who almost ran last fall as well, and he withdrew due to Hatch Act issues, which is regarding federal pay and funding. So I mean, it's a sticky wicket, and it's certainly not one that has boded well for the city this past term, I don't think. I want to welcome Bill Cornish, who has made his way in here just in the nick of time. And Bill, welcome.
Yeah, but I'm sorry to be so late. I hope you invite me back again.
Well,
next week even.
We can do that. I want to give Bill a chance to talk about what Lotta is doing. Bill's a former New London City Councilor. He's served 2 terms, one as an elected Democrat. He had a couple of terms off, and he got reelected as a third-party candidate with One New London.
Yep.
He's a downtown property owner and business owner. He runs the Copperwoods on O'Neill Drive. He's a spokesman now for Lot. And what do you got for us, Bill?
Well, I was at the city council meeting last night, and the mayor says that he's not going to let this petition proceed. I think it's a very foolish statement to make. It puts the city clerk in a bad position. I mean, if we go out and get this petition, we present it to the city clerk, which is the process, and he's been told not to verify and not to count them and not to let them move along. I hope the city council gets involved and sees that the law is followed, and it's the law to, if we go out, take the petitions in to the clerk and he processes them. Now there's this interpretation that everybody wants to make on their own as to when you spend 25% of, equivalent to 25% of last year's budget, can you go forward? I'm saying you can go forward. I think that 25% was to light a fire under people and say, get your budget done. Not that if you get 25%, you have to stop. Because that would tell any city council that we never have to hear from the people. That would say, drag out this process, the budget process, let people go out once, and then we'll be at 25%. And they could prepay something and be at 25%. And then they don't have to hear from people. This is the opposite of the way it's supposed to be here in America. The government should welcome input from the people. This administration under Mayor Finizio is not, in my opinion, not Lott's opinion, my opinion, he's not welcoming to input. So I just don't understand this violating the charter, because I don't know what, I just don't know what the reason is.
Well, let me ask if Lot initiates a petition drive.
We are. Here's the petition here.
And is this going to be of similar nature to the petition and referendum questions that we just rejected a few weeks ago?
Yes, right.
So it's basically it's dealing with the budget and dealing with the mill rate.
Yes, right. And several people have gone to the city council and made suggestions about how things to save on and how to generate more revenue. So it's not like the council hasn't heard from, and I'm sure that the mayor's paying attention. It's not like they haven't heard some suggestions. And some of them might be off the wall, some of them might be valid. I think they ought to spend some effort into investigating these suggestions that the citizens are bringing to the city council and see, in fact, if they can reduce the budget more. And they think they're at rock bottom. I don't think they are. As a private citizen, I don't think they are. And plus, I have a concern on how our money is being used. I say our money because until we turn it over in the form of taxes, we can say it's still ours. We know it's leaving us soon. But right now, I think that we ought to look hard at some of the processes in the city. Like, I know they're trying to get a handle on overtime, but last year, this town spent $3.5 million on overtime. One individual alone made $70-something thousand in overtime. There are many people that make over $20,000 a year in overtime. So those, you know, it's a little confusing with the mayor form of government, but because the city council really doesn't control the departments, the mayor controls the departments. And most of this was on last year's. But there's nothing that I see that says there's control going on, so we don't have another this year like last year. Now, Passroll, the president of the council last night said, we have reports now and we're trying to, you know, hold this stuff down. But that's the kind of thing I think people want to feel assured that our money is not, it's getting good value. It's not being pissed away and not being wasted. Because we hear stories about people coming in and doing routine work on overtime. And of course, there's all kind of rumors and stuff going on. I don't know if that's valid or not. But I think all that stuff needs to be looked at.
Yeah. But based upon the mayor's statement last evening, and I happened to catch him on Channel 22 by chance, I might add, making his dissertation.
Yes,
and he was pretty clear that he's not going to accept this petition.
Right, he's not going to do anything unless a judge orders him to do it.
That's correct. So in essence, he's laying down a gauntlet here that, okay, you can do what you want to do, but it won't be accepted, so therefore it's going to require legal action to get him to move.
Yeah, that's very peculiar to me.
And,
you know, we have a charter, why not just follow it?
And you know, I spent a good part of the program going through the Hampel versus New London case in 2008, which I think is, I won't say riddled with loopholes, but it's not firm across the board in terms of its analysis.
I hope you went on the timeline for this thing, because technically, I think the charter, the clerk has 10 days to compilate things to make sure they're all legitimate signatures. That time, something was amiss because it took many more than 10 days to get out of the clerk's office, and then we had to get on the docket of the court, and it took months. So it really went into almost the summer of the year after we did the petition. So essentially a judge said, well, what the hell is the use now? So, but this is different. You know, I know it's October.
Now let's say that the petition is circulated and it's presented to the clerk's office.
Right.
On X date, and he's got a certain amount of days.
He's got 10 days to do it.
Do his business.
Yep.
And according to at least this case, and I don't believe that the charter has been changed in this area.
Yeah, I don't think
that in turn it then gets sent to council, not the mayor.
Right, it's the council's responsibility. The budget is essentially, even though the mayor produces the budget and sends it to the council, they both have to approve it.
Yeah, and what the mayor is saying is that he won't accept it, even if the clerk reviews it.
Right.
Which I find puzzling.
Well, plus, you know, why would we do this to ourselves? If the people feel strongly enough and this comes in and he rejects it, well, they might start a lawsuit against the city council, the mayor, the city clerk, and then have to pay a lot of legal fees. The people that the people that start this lawsuit would have to do the same thing. We have a charter. We just have to follow it. I don't think the mayor has the power to order a change in the charter by himself. So I think he's on the line.
Yeah. We've got 1 minute, and I'd like to give you an opportunity to let people know where these will be available.
On Friday at the at Stop and Shop in Waterford, there'll be some folks there, and if you want to volunteer, please give me a call. There'll be some folks there with a petition and with a flyer. And on Saturday at 134 State Street, which is between Sarge's Comics and Monica's State Street Diner, there's a vacant storefront there, and we'll be there. So there's a place Friday and there's a place Saturday. And I'd like to give my number, 860-861-1323. Call me anytime. These are always on the counter at Copperwood Grill at 24 Eugene O'Neill Drive. They're always in my truck, so if you see me, just wave me down, and I'd love to have you sign this thing. I think we're now starting to screw with our basic rights as American to petition our government, and I think the mayor is way out of line saying he's not going to allow that. It's much deeper than money.
I agree. And I want to thank you for making the effort to get here. Better late than never.
Right.
In reference to our second caller this evening, who indicated that she was less than enthused with my push on education in my run for mayor, I do like to just comment that I think that the presence of a special master and state oversight of our educational system buttresses my thoughts regarding the what's going on with our schools. Bill, again, I want to thank you.
Okay. Thank you.